All right, this is for my 1100 class. This is an overview of the law of contracts. If you pay attention to nothing else, pay attention to this. And that's because our lives are literally governed by contracts. And this class will be coming up in the spring, just FYI. So make sure that you knock it out whenever it comes around. And I'm telling you, it will change the way you do business with people. All right, you have two types of governing law. You have the common law, and then you have what we call the UCC, which is the Uniform Commercial Code. Now, the most prominent part that we use out of the UCC is Article 2. There's several other articles, but this one is the one that covers specifically the sale of goods. All right, so you have two types of contracts. You have the unilateral, which is a promise for performance, and then you have bilateral, which is promise for promise. Let me show you what that looks like. I promise to pay you $500 if you paint my shutters in the next 2 weeks. So I'm promising you money in exchange for your performance. You have absolutely zero obligation to show up and perform. But if you do, then I'm on the hook for the $500. Now, I promise to pay you $500 if you promise to be here on Friday to paint my shutters. We have now both made a promise. So if I don't pay you, then I breach. If you don't show up, you breach. So this is what it looks like for the difference between the unilateral and the bilateral. Okay, to have a valid contract, you have to have two parties minimum, which if you think about it, you can't contract with yourself. You have to have legal capacity. That means age plus the mental capacity. Now, with the mental capacity, they're looking for somebody who can understand and appreciate what it is that they're contracting for. With age, you do have the ability for minors to enter into a contract, but there are only certain types that are going to end up being enforceable. This threshold, though, makes it so that companies do have the ability to say, I'm not going to do business with you unless you're at least 18 years old. Then you have to have a valid offer, a valid acceptance, consideration, and mutual assent. And these we're going to talk about in more detail independently. So the definition of an offer is an expression of willingness by one party to enter into a bargain with another made with definiteness of terms. But what's definiteness of terms? Q-tips. And I'll show you what Q-tips means in a second. And this will be the easiest way for you to remember what it is that is needed for a valid offer. The definition for acceptance is when an offeree intends to be bound to the bargain to perform as the offer requires. And then consideration is something of value that a promisor receives from the promise in return for their promise, which can either be, like we talked before, in the bilateral, that would be a return promise, or in the unilateral, it would be whatever performance is required. So Q-tips means Q for quantity, T for the time of performance, I for the identity of the parties, P for price, and S for the subject matter. For example, I promise to sell you my house for $500,000 to close in 30 days from today. So we have the identity of the parties. That's me and you, okay? We have the quantity. It's one. And we have the subject matter, which is a house. So you and me, the parties, one house, that's the quantity and the subject matter. $500,000 is the price. And the time of performance is in 30 days from today. So when you have a valid offer, it's going to contain the definiteness of terms. Now, there are some exceptions to the rule, but we'll cover those when we actually do contracts in the spring. So the offer has to be communicated. Think about it. If somebody doesn't know that an offer is on the table, they can't accept. So it has to be communicated, which in turn creates the power of acceptance in the offeree. And they have to also intend to enter into this bargain. They have to intend to be bound to what it is that they're putting forth, right? And it is different from an invitation to deal, okay? These are not binding, the invitation to deal. These are similar to an offer, but they don't demonstrate the willingness to enter a bargain. And let me show you the difference between the two. I would consider invitation to deal. I quote you a price of invitation to deal. Would you pay? Invitation to deal. Are you interested in? Invitation to deal. As you can see, all of those are not exactly intending to enter into something binding. They're basically just feeling you out to see if it's something you would be interested in. I will buy. That's an offer. I will sell. That's an offer. I will not sell. Also an offer. So as you can see, the language is much more definitive when it comes to it being an offer versus it being an invitation to deal. But let me show you a better example. So Scotty and Sam are getting ready to go on their annual hunting trip with Sam's work. He needed a new gun, so he went to a local dealer to buy the gun. Sam says, I would like to buy that shotgun and 3 boxes of ammo for it. That's an invitation to deal. The dealer says, okay, that will be $600. So he's putting it out there. Now, go back to Q-tips, right? It doesn't have like all of those right there in the $600, like that will be $600. But if you go back and look, we know the identity of the parties. They are Sam and the dealer. This is implied by the fact that Sam is in the dealer's store. Then you have the quantity. So he wants 1 shotgun, which that's the quantity and the subject matter. And then he wants 3 boxes of ammo, also the quantity and the subject matter. Now we have the price, which is $600. And because this is a retail transaction, we know that these are on, at the point of sale. So we know it's all going to be done right then. So this doesn't have Q-tips spelled out, but it's implied and it's there. So this is a valid offer. When Sam hands him the money, that becomes the acceptance. Bonus though, what kind of contract is this? This is a unilateral because again, this is a promise for performance. The dealer doesn't have to say, I promise to sell you this for $600. He's saying, hey, I'm going to give this to you for $600. And that's as good as you can get when it comes to some promises. And then all it takes is for Sam to turn around and give him the money because, again, this is a retail transaction. All right, let's look at another. Same situation. He needs to buy a new gun. And Sam says, I would like to buy that shotgun and 3 boxes of ammo for it. Again, an invitation to deal. The dealer says, okay, well, I will sell you some for a fair value. Again, an invitation to deal. Sam says, how about $600? Dealer says, perfect. So we have an offer and we have an acceptance. Now, retail stuff is all around us. And sometimes, we see these ads in newspapers and, on social media and all kinds of things. And the question comes up, at what point is an ad an offer, or can it even be an offer? So that's one of the next things that I want to kind of go over with you. So for example, Macy's advertised that all of their Skechers would be on sale for $30 a pair, any style, any size. And A went to Macy's to purchase some and they were sold out. A filed suit claiming that Macy's ad was an offer and that she accepted by showing up to purchase. So was this an offer? No. And I'm going to explain to you why. So ads can be offers if they indicate that intent to enter into the bargain, right? It also has to tell specifics for the offeree on what it is that they need to do without any other kind of communication that comes from the offeror. Or there has to be that there's the over-acceptance of the ad is unlikely. So let's break this down bit by bit. So again, just to refresh, Macy's advertised that all of their Skechers would be on sale for $30 a pair, any style, any size. A went to Macy's to purchase some and they were sold out. A filed suit claiming that Macy's ad was an offer that she accepted by showing up to purchase. So did it indicate that there was an intent to enter into a bargain? Maybe, but do we really, know that for sure, right? Because again, let's go back to Q-tips. Does Q-tips exist? We could argue that most of it does, at least. We have the parties, which is A, and Macy's. We have the subject matter, which is the Skechers, any style, any size. We know that they're $30 a pair, and we know that it's a point of sale issue. So we know that it's going to take place right then. So what we don't have, though, is the quantity. But again, there are situations to where the quantity can be filled in by a court if there's a gap filler that can be used. But we'll come to that when we take contracts in the spring. But let's go on. Did it invite the offeree to do something without requiring any further communication? Yes. It required somebody to come to the store and actually, pick out whatever style and size it is that they wanted, take it to the register, and pay the $30 per pair. Yes, per pair. And in that case, there was no further communication. They didn't have to say, this is what you need to do. All it takes is knowing that this is how the procedure works. Or go online, place it in your cart, check out, that type of thing. We know it as shoppers. So where this one comes down to is, was over-acceptance unlikely? And that's a no. So they can't have this as an offer because we know that people are going to flock to stores if something's like an amazing deal, right? We know that people are going to go gobble them up, and over-acceptance is likely. So in this case, this was not an offer. So let's talk about Lifkowitz versus the Great Minneapolis Surplus Store. And this is actually a really great case that is where we get all of this from on whether or not ads can be offers or not. So this store put out an ad that said, like, something along the lines of, say, Saturday, July 15th, from 9 a.m. to 12 p.m. Fur coats, $100, first 10, first come, first serve. Okay. So you have this man who shows up, and he was going to go get his wife this coat. And he goes up to go pay, and they said, no, we're not going to sell it to you. This is for women only. And it didn't matter the fact that, he was buying it for his wife or anything like that. They just turned him down altogether, even though he was first in line. So what happened was he filed a lawsuit, and they came back and they said, well, did this constitute an offer? And so they looked at it and they said, yes, it did. And the reason that it did is because they gave the definiteness of terms. So we know that the parties are the store and whoever the shopper is. We know that it's the first 10 shoppers. So whoever they ended up being, that's who, the parties were. We knew that the subject matter was the fur coats. We knew that the quantity was, 10. We knew that they were $100 a piece. And we knew that it was happening, say, July 15th from 9 a.m. to 12 p.m. So whoever the first 10 were on that day could have the coats at that price. So they came back and they said, you laid out all the terms. So now you made it so that the person is going to show up. And it goes back to that, was the over-acceptance unlikely? And in that case, yes, because they actually restricted it down to just the 10. So in that case, this all did become an ad. But let's talk about it a little bit more in detail. All right, so for example, A put an ad on Facebook Marketplace to sell her car for $1,000 or best offer. B showed up with $900. Does A have to sell the car to B? No. Again, this is an invitation to deal, really, more than anything. So she has the right to accept $900 and say that that's the best offer. Or she can say, you know what? Not interested. I'm going to hold out for, a little bit more. Let's talk about rewards. Are they ever an offer? A lost his dog and put up flyers for a $500 reward. B found the dog and called the number on the tag. B returned the dog. When she was leaving, B saw the sign outside regarding the reward. B went back to the door to demand the money. Does A have to pay B? No. And that's because this is called past performance. And whenever you have these types of situations, you're still looking for the valid offer and the valid acceptance. And you've got to have that consideration. And in this case, they're trying to use past performance as consideration. They did not know about the offer. Therefore, they could not accept, and they can't go back in history to accept. So what if A lost his dog and put up the flyers, and B saw the flyer and went around looking for the dog and then found the dog? B contacted A and returned the dog, and B demanded the money. Does A have to pay B? And in this case, yes. And that's because B was induced to perform by this promise of payment. B would not necessarily have gotten up to go look for this dog, but maybe B really needed this $500. And so B's like, I'm going to put my, best effort in, and I'm going to find this dog, and I'm going to get that money. So again, when you have this inducement, then you're saying, okay, well, this is a valid offer. This is a valid acceptance. They go out and they do what it is that they're supposed to do, which is find the dog and return it. Then A has to pay the $500. All right, so let's talk about what kind of contracts are not valid. We have agreements that get made in jest, and this one, you have to really toe the line on this one. And that's because there's a leading case called Lucy v. Zimmer that governs this type of law. Now, what happens is that the court will look to what would a reasonably prudent person think if they are sitting on the outside looking in. So in this particular case, you have these two couples who are at dinner, and they are talking about one making an offer on the other person's house, right? So would the reasonably prudent person in this particular situation think that this was something that was done in jest? So if you have them sitting there talking about, I'll pay $5 billion for your house, and you know that there are no houses anywhere remotely close to you that are worth $5 billion, then you probably think, they're just kidding, right? But in this case, they had written down the agreement on a napkin, and one person basically took the napkin to the court to enforce the deal. And the court came back and said, well, what would the reasonably prudent person say if they were listening to you guys make this deal? And in this particular situation, you have these couples, and they're having this 45-minute conversation about what this contract would look like. Then on top of that, they wrote it down, and then they turned around and wrote it down again so that the wives could, also sign off on it. So everybody was technically in agreement according to the reasonably prudent person. And it was a deal that would not have made the reasonably prudent person go, there's no way, that's just a joke. So just wanted to throw that out there. Be careful about what you say. All right, you have your negotiations. And again, these are conversations where it's just invitations to deal. These are just the back and forths. And these technically, whenever we get into contracts in the spring, you'll learn that these are offers and counter offers. So they can be valid offers, but when you've got the negotiations and they are going back and forth, it is an offer counter offer situation. You have future gifts. This just speaks for itself. You can't enforce something that's in the future. A legal obligation. Let's say that your house is on fire and the fire department shows up, and you tell this guy who's one of the firemen, you say, listen, I will pay you $500 if you put that fire out. That contract cannot be enforced because there is a legal obligation on that fire person to put that fire out. So they can't come back and say that it's enforceable. Advertisements. I know your book says no, but I already showed you how they could be. Indefinite promises. Again, this is more like a future type thing. Not happening. Auctions. This one also is not necessarily true, and we'll talk about that more in the spring as well. And then you have illusory promises. And illusory promises are going to look like, actually, let's back up for just a second. If you recall, With the unilateral situation, it was, I will pay you $500 if you paint my shutters, right? So in that kind of a situation, you're waiting for the person to show up, right? Or maybe you're doing it in a bilateral situation where you're saying, listen, I promise to pay you $500 if you promise to be here on Friday to paint my shutters, right? So what happens if the person on the other end says, well, okay, here's the deal. I promise to show up on Friday if the weather's above 75, it's not raining, and I feel like it. Remember that all of this goes back to an intent to be bound. And when you start having language like if, maybe, things like that, that's showing that the person doesn't intend to be bound. They're basically throwing out all this fluff. But in a situation like this, it creates an illusion that the person might come through, right? Especially if you have looked at the weather forecast and you're like, oh, there's no way it's going to be, above that. It's not going to be raining. And so now we just have to get through the if they feel like it part. So in that case, though, you still have this illusion that this promise exists, and it doesn't. Again, the person could show up, but again, it doesn't mean that they're going to, and this is an illusory promise. All right, so let's talk about acceptance and what that looks like. And first up is the mirror image rule. And this says that your acceptance has to mirror what the offer is, okay? Or be reasonable where silent. And by the way, in contract law, just so you know, silence is an affirmative answer. And what that means is if you are silent, then the court will assume that you have agreed to the terms because you had the ability to come in and object. You had the ability to say your piece. You had the ability to counteroffer. You had the ability to do all of these things, and you did not. Now, what it means by you have to mirror the offer, for example, I promise to pay you $500 if you show up to paint my shutters. When you show up to paint my shutters, you actually start painting my doors. That's not the mirror image. Painting my shutters is the mirror image. Or, hey, I promise to pay you $500 if you promise to show up and paint my house or paint my shutters on Friday. You say, I promise back. That's the mirror image. So we're looking for things that are going to be the mirror image. The mailbox rule states that the offer becomes effective once it is mailed to the person, and it does bind the offeror. Now, one thing I will say in terms of the mirror image rule and the mailbox rule kind of together is the offer can stipulate how a person can accept. So if it states that you have 24 hours from the receipt of this offer to put your your offer or your acceptance in, and it has to be sent by certified mail, and you send it via fax, again, not the mirror image. So mailbox, though, this is literally snail mail, and it is effective upon mailing. Email is going to work really the same way, and fax is going to kind of work the same way. So basically, it's going to be about when something gets transmitted back to the other person. And I know you're probably sitting here thinking, how can you track that? Like, does it have to be certified? Does it have to be registered? No, it doesn't have to have any of that stuff. It just has to have somebody saying, yeah, I put that back in the mail. And this is where contracts get sticky. Silence as acceptance, like I said, you have to say something. If you don't say something, then you are going to end up with a whole bunch of problems. I use the concept of the non-conforming goods as an example. So the non-conforming goods means that you have a store and you have ordered inventory, and you've ordered 1,000 shirts, and you wanted 200 of them to be pink, 200 of them to be black, and the rest of them white. And you wanted them broken up into 33%, like a 1/3 of each size, small, medium, large, right? So this is what you've put in, but they send you 500 red, 200 yellow, and then 300 purple. Okay. They might send you the right sizes, but they sent you the wrong colors and the wrong quantities. So in that particular case, you have non-conforming goods. You have to say something, because if you don't say something, then you are on the hook for those goods. And it will be assumed that you have accepted this substitution as your order. All right, so let's talk about third-party contracts. You have three types of beneficiaries. You have your donee beneficiary, your creditor beneficiary, and your incidental. And these also do get created under what's called assignment and delegation. And we're going to talk about all these. I'm going to give you examples of what they are. So a donee beneficiary is a person who benefits from a contract gratuitously. Let me give you an example. So A's neighbor just had a baby. He hired B to clean the neighbor's house for a month while she recuperated. So you have A and B who are parties to the contract. The neighbor is not, but they benefit from it. So this is where you have where donee, it's somebody who's getting something basically donated to them. A creditor beneficiary is a person to whom an obligation is owed by the promisee. So again, A's neighbor just had a baby, and he hired B to clean the neighbor's house for a month while she recuperated. B hired C to do the cleaning for 3 weeks. Okay. In this case, you again have A and B who are parties to the original contract. Then you have B and C who are parties to the subcontract. Now you still have the neighbor who is not a party, but they benefit from it. And you have A who is a third-party creditor beneficiary. So A is going to be paying B, and remember, it has to go back to the promisee, which the promisee in this case is B. So B is responsible for paying C. All right, then you have the incidental beneficiary, and this is a person who is not a party to the contract, and they become an unintended third party to the contract. They are not explicitly promised any benefits, but they may stand to benefit under certain circumstances. Now, in the other two cases, you didn't necessarily have any promised benefits. However, once that person was paid to come in and do the cleaning, then if the cleaning did not take place, then the neighbor also had standing to do something. But this one is a little bit different. So let me show you what this looks like. So you have A, who hired B to install new sod and to maintain landscaping on a regular basis. A's lawn has been an eyesore in the community for a while. So once the lawn has been turned into this, well-manicured version, property values go up. So you have A and B who are parties to the contract. C is incidental beneficiary because their value also increases. So it's something that benefits everybody. All right, so you have the plain meaning rule, and that is the use of ordinary meanings and definitions when it comes to interpreting a contract. Now, I'm going to give you a case about this, which is a fun one. It's the Oakhurst Dairy case. Now, here's your background on it. You have these drivers who were suing for overtime, and the Maine law stated that overtime was at 1.5 times the rate for any hour that was over 40. Now, these were the people who had their trucks packed with the dairy products, and then they were going out and they were actually delivering it, right? And you will hear me say this so many times. Not only do words matter, but punctuation matters as well. And that's because this is the case of an Oxford comma, all right? Keep in mind that the judicial branch, their job is essentially to interpret legislative intent, right? So the law stated that there was an exception, and it says the canning, processing, preserving, freezing, drying, marketing, storing, packing for shipment or distribution of agricultural produce, meat and fish products, and perishable foods. Okay, so this is what the law said. And in this particular case, so the court focused on the packing for shipment and distribution of. So they came back and they said, had a comma been put in after shipment, then the legislative intent would have been clear. But look at those two statements, packing for shipment and distribution of, or packing for shipment and distribution of. So one makes it so that you have people who are packing trucks and delivering. So like they're packing their own trucks maybe and doing deliveries, or I don't know, maybe it's just the people who do that. But then you have the people who are packing for shipment and then the people who are distributing. So again, they said that this comma basically meant everything. And they were going with the plain meaning of all these words when it came to packing for shipment and distribution of. I know that we hear all of this, legalese a lot. And the reality is that the courts don't actually use it as much as you probably think that they do. And they do look to the plain meaning of things when it calls for it, which is usually the rule that they rely on the most. I apologize for any squeaky toys or squeaky pigs you hear in the background. My dog will not leave from in front of my office. So let's move on to an unconscionable contract. And it is one that is so outrageous or immoral that it shocks the sensibilities of the courts. Now, this is a defense to formation. And it's where they're coming back and they're saying, look, you can't enforce this contract because this contract is unconscionable. And it comes from the UCC, remember the Uniform Commercial Code, Article 2, -302. And this applies to all contracts despite whatever governing law there is, okay? And this allows the courts to come in and refuse to enforce these types of contracts. They can enforce it without the unconscionable clause, or they can limit the unconscionable clause so that it is not unconscionable. Let me give you an example because I know that I just said a whole lot that probably made no sense. A is flipping a home and was facing a shortage of appliances due to COVID-19. This really did happen too. The $200 dishwasher that A needed to complete the kitchen had a market price of $500, but the store was selling it for $1,200. A ordered the dishwasher along with a new faucet and a light, which were at their normal prices. When the products got delivered, A refused to pay the $1,200, and the store filed suit. So, what could the court do if they decided that this was an unconscionable contract? Again, they can void the contract. They can void the contract portion for the dishwasher only, or they can modify it, okay? If they void the contract, it is going to void the entire thing. It is like the contract never existed whatsoever. Now, if they void only the portion for the dishwasher, then you would still have A owing for the faucet and the light, which were at their regular prices. Then you have where they can modify it, and they would only owe the $500 market price plus the plus the light and the faucet. So this is an example of what it would look like if the court stepped in on an unconscionable contract. All right, so you have adhesion contracts, and these are contracts where parties have disproportionate bargaining powers that the weaker party could not have negotiated any variation in the terms. What do these look like? These are actually the contracts that are probably in our lives more than anything else. You have mortgages, insurance policies, credit card agreements, house rentals, car purchases. These, like I said, are the contracts that are typically in our lives the most. But what do these contracts actually look like? They're the ones that are on the standard printed forms. They're the ones that have that boilerplate language on the back that you cannot go in and negotiate on whatsoever. They are used for mass demands for goods and services. They are drafted for indefinite amount of people instead of it being tailored to the individual. And then these are considered valid and enforceable unless there is some reason for it to be considered unconscionable. So these are your standard run-of-the-mill contracts that we all sign. Now, what does it look like when we're talking about unconscionability? So you have this extreme inequality of bargaining power between the drafter and the signer. I would argue that we already really have that. I mean, if you're kind of, going up against, you got a contract that you're signing with, say, a big, mortgage company, I mean, there's already an inequality there. But nonetheless, I'm going to give you an example of what they're really talking about. The contract language that a non-lawyer signer would not understand. This is your legalese stuff that's going to get put in, or it's going to be drafted in such a way that it says a lot and it's said with words that are meant essentially to confuse. Then you have exploitation of underprivileged, unsophisticated, uneducated, and illiterate people, an imbalance in the obligations imposed by the contract, or contract provisions that are inconsistent with the signing party's reasonable expectations. And I'm going to give you an example that's actually a true story. I just left out the names. So A was a high school dropout who worked at a hotel or as a hotel housekeeper. She had no checking or savings account, and she took out a loan for $200 on a take it or leave it basis. The terms were for her to pay 26 biweekly payments of $60, which were interest only. The 27th payment was for $60 in interest plus the original loan amount. The total payments for the loan would be $1,820 with an annual interest rate of $838.45. The following day, she broke her hand and could not work, and she defaulted on the company and filed suit. Now, this is based on the real case. You can look it up. It's I can't remember her first name though, but it's James v. National Finance or National Financial LLC. And the court did find that there was inequality in this bargaining power because you have that take it or leave it. You have that situation to where they say, look, it's these terms or nothing else. And you don't really have any ability to go in and say, well, I don't want that. I want my interest rate to be a little bit lower, or, I want the governing law to be Georgia, whatever. Again, inequality. They also gave them it was a 6-page contract where they had, 5 pages having substantive law language. So 5 pages of, legalese essentially, and then 1 page where they could easily understand it. And then the interest rate, oh my God, 838%. That right there, that shocks the conscience. So that's an example of what it looks like when you're talking about these adhesion contracts where it is unconscionable. Remember that these adhesion contracts are a take it or leave it. Yes, you do have the ability when you go in to buy a car or a house or whatever to negotiate your payment, to negotiate how much you're going to put down, to negotiate, your interest rate and things like that. But you don't have the ability to negotiate on anything else. It is just those few things. And that's what they mean by take it or leave it. After you get down to that, you have to either take the deal or you leave it, because you don't get to negotiate on anything else. All right, the statute of frauds. This is also a defense to the formation of contracts. And it's a doctrine that we brought over from England. And it says that certain contracts have to be in writing. And that is where you have a promise by an executor of an estate. For example, like I'm an executor of an estate and I say, I will pay that contract. Okay, that's me making a promise in my power. Promise by one party to answer for the debts of another. That would be like me saying to my son's, people who finance his car, hey, I'll pay his payment for the next 3 months. I'm answering for the debts of him. Promise given in exchange for promise of marriage. This is not what you think it is. It's not like a prenup or anything like that necessarily. This is where you have things that are going to be promised. Like, for example, if you get married, we will give you grandma's house. Okay. In that case, that needs to be in writing, on top of the fact that, it should already be there in writing, because Next one is promise to sell, transfer, or convey interest in land. Promise for the sale of goods exceeding $500 and agreements that cannot be completed within 1 year. All right, so fraud in the factum is where one party made or signed an agreement not realizing that it is supposed to be a contract. Now, your book calls it fraud in fact. It is a legal defense to the formation of a contract, and the person may not understand the content or purpose due to some sort of, false information. When I say that they don't understand, this is where elderly people get taken advantage of a lot. You also have I give you the example of an alteration of a contract without knowledge of the other party. Now, I gave you an example at the bottom of something that I do whenever I was like drafting things. I would always put down there a way for there to be initials. I do that essentially on almost everything. Like if I ever drafted a will, I have them initial everything. And I have the witnesses do it too. And then if there's a power of attorney, they have to initial everything. The settlement agreements, they have to initial everything. And that's because, yes, those can still be faked. You can still have somebody who's going to slide a page out and slide a new one back in. And yes, they can go in and fake it, but it's going to be much harder for them to do it. And it's going to be much harder, especially when there is proof in other places that the one copy that they have isn't what everybody else has. So anyhow, just wanted to give you an example of what that looks like. Now, fraud in the inducement. This occurs when one party is involved in the contract and they use deceit or trickery to get the other party or signer to act for their advantage. And this is an equitable defense, and these contracts are illegal. They are voided, and there is the result in the dismissal of duties so that it is as if the contract never existed, okay? It is like you have basically it dismisses the other party's, obligation to act as well. I'm sorry, somebody was just driving up my driveway. This is where one of the parties has been misled by facts and the wrong facts were used for the party's decision. And I use the example of A told B that they were an investment broker in order to get that money. So once they get their hands on that money and now they go do something else with it, they've done fraud in the inducement because they said, listen, I am a professional. This is what I do for a living. I'm going to help you turn this $10,000 into $1 million. Okay. All I need you to do is just trust me and give me that money. Right. And when it induces them to do something, then that's what happens. All right. Let's talk about other defenses. You have the absence of one or more essential element. And this is where the court is able to use gap fillers. Now, the court can only use gap fillers for Q-tips in some of those categories. If there is not the ability for the court to have some sort of ability to have an input, like, for example, they can't come in and tell you what quantity you actually wanted, but they can come in and they can talk about price, right? Because they can go by industry standard. So let's say that you are renting a facility and you think, let's say that it's for market price according to the lease, and you think that the market price is for $1,500 a month, but the landlord says, no, it's for $3,000 a month. And so you guys have to now take it to the court for the court to come in and say what the actual market value is. Now you have the accord and satisfaction, and these are actually two separate things, but they go together. So let's say that you owe Capital One $500, and they come back and they say, listen, if you just pay me, $250, then we will close the account. It won't show as a charge off. We'll show that it's in good standing, and that's it. So if you agree to it, then that becomes an accord. So the accord is essentially the new contract that is in place for the original. And once you pay it, then it becomes the satisfaction. And so that's taken care of. Then you have a justifiable breach. And this is where you have somebody who gets excused from performance, again, because it's justified. If you have somebody else who breaches, you should not be expected to perform simply because you're also a party to that contract. The other party's already screwed it up. Then you have impossibility. And this is where you have like the subject matter gets destroyed, right? So let's say that you have a Picasso and you're selling it and it ends up getting destroyed. You can't fix that. That's a one of a kind, right? So it's impossible, and that would end up being a defense to the contract. Impracticability, it's where it's physically possible, but it would cause hardship. And I'll show you some more on the next slide. And then you have frustration of purpose. And this is where you tell somebody the reason that you're entering into the contract, and that somehow gets messed up. So for example, let's say that you are going out and you're looking for property. And this property that you're looking for is property where you want very desperately to have, a barn and stuff like that. You want to be able to have horses, and you want to have like this therapeutic camp, and you have this whole vision laid out where kids are going to be able to come and ride horses and groom them and, play with them. And it's going to be therapeutic. And the seller even is like, oh yeah, this would be great property for that. And, you guys are talking about it. But then you go and you find out after you've already put in your offer, you find out it can't happen. It can't be zoned for that. So in that case, your frustration has now been, your purpose has now been frustrated. All right. So impracticability, this is where you have a defense to the contract again, and it has to be more than just a temporary situation. So you have the types where you have the subject becomes illegal before performance. You have the subject becomes destroyed. You have goods that were supposed to come from a particular place, and the supply of goods from that place fails. And then you have the subject is destroyed after performance is started. So let's use the example. I have CVS and Bayer Aspirin. Let's say that CVS places an order with Bayer Aspirin, right? And they want to buy tons of supply for all of their multiple stores, right? And they are supposed to have it shipped out on August 1st. But on July 15th, the U.S. government signs into effect a law that bans the import of aspirin. So in that situation, the subject matter of this contract, which is the aspirin, has become illegal before performance was required, which, is about 2 weeks ahead of time. So this is impracticability because, again, it is where it's where you can perform, but there is a hardship. Could they go and find like another supplier or a way around it? Could they lobby? Could they do this? Like there's all kinds of things. They could sneak something in through, maybe some kind of underground type situation, whatever. Again, it's just become impracticable. All right. And then you have the subject becomes destroyed. So let's say that the Braves have, they have signed up to do these games, right? And they're supposed to, they got their contracts and they're supposed to be paid X amount of money per game and all of this, right? But then right before the season is supposed to start, the stadium is burned down. Well, in that case, they can't play. Could they play somewhere else? Yes. But they can also build it back, right? Yes. So again, this is one of those situations to where we're looking at it as it's not impossible to perform. It's just not something that is going to be easy for them to perform, or it's not going to be something that is going to be readily available. Let's say that the goods were supposed to come from a particular place and the supply of goods failed. So, whenever we do contracts, you'll hear that I use like orange juice as one of my main kind of situations. So we're going to pretend that we're doing an orange juice company, right? And you're buying some oranges from a main supplier and they've got, crops in California and they've got crops in Florida, right? And let's say that their best oranges, the juiciest, best ones come from Florida. But Florida, for some reason, has had their crop fail. If the contract states that it is supposed to be from that particular orchard and that orchard has failed, then the other party is going to be excused from performance because, again, can they produce more? Yes. Can they do it in the right amount of time? No. So again, it's impracticable for them to do it. And then you have the subject is destroyed after performance. Now, I want to point out that this is typically where you have construction type stuff, and it's where you're repairing a building, right? Not applicable for new construction because that can be done. Again, you start from the bottom and you go back up, but it's going to be where you're repairing a building where you're not going to be excused necessarily from performance. It's going to be the level basically that they're looking at and how impracticable it would be in that particular situation. So, and if I haven't told you, I'm telling you now, construction law is hands down my favorite area of law. That has some juicy, juicy contracts in it. All right, let's do the last slide. All right, so we have remedies and we have expectation damages. Your book calls them compensatory damages. It doesn't matter. It's either one. These are going to be the damages that one would expect when entering into the contract as if the contract had been completed. For example, if you purchase a car for, say, $10,000 and that car gets repossessed, right? What they're supposed to do is they're supposed to mitigate their damages. And so they go and they sell it at an auction and they get, say, $1,000 for it. And there's still a balance due of, the $4,000. They're going to sue you for that $4,000. You don't have the car anymore, but they expected that $10,000 and they're going to sue you to make sure they get it. Now, restitutionary damages is where the contract is set back as if it was never started. I guess that's the best way to kind of explain it. So expectation sets you to the end. Restitutionary sets you to the beginning. So that would be along the lines of, I promise to pay you, $500 for you to paint my shutters, right? And you go out and you purchase the paint. And I asked you specifically, I'm like, listen, I need you to make sure that you're here by Friday. And you show up and I have other people who are there painting. I didn't give you the opportunity to know ahead of time to not buy the stuff. So you now have incurred expenses because of me. So I owe you the money for that. So that's restitutionary damages. It sets you back at zero. Liquidated damages are clauses that go into contracts. And again, these are typically estimates for breach. Like going back to construction, my husband's contracts, he's a VP of a construction company. And they have these clauses that are built in that say things like, if you don't, get this phase done by this time, then you will owe $1,000 a day. That's your liquidated damages right there. And then specific performance is used for things that are considered unique. And that's because you can't just go and replace it. So might be where you have, say, a house. In fact, I'll use an example straight out of something that happened with me. When we were house hunting, we came across this house. It was the second house that we put a bid in on, and they accepted our offer. And we were in the process of trying to set up doing the appraisal and all of that good stuff. And they didn't they kept putting us off. And we're like, this is weird. And anyhow, so they did that for about 2 weeks. And then they ended up coming back and they had revoked their acceptance. Now, we could have taken them to court and we could have sued for specific performance. And that would have forced them to have to sell us the house. It's the same thing that happened in that Lucy v. Zimmer case, where they had the agreement over the house and whether or not that reasonably prudent person thought it was an offer in jest or not. Same thing. They use specific performance. If you're, contracting for a Picasso, same thing. You can't, it's not something that you can just go out and replace. So that's what you use that for. Anyhow, that's it for this overview of contracts. Again, we'll be doing it in the fall, in the spring. It is hands down one of my favorite classes to teach, so I can't wait to do it again. If you need anything, please reach out to me, email me, call me, whatever it is that you need, and I'll be glad to help. And that's it. Bye.